Rosati, founder and CEO of Women Get On Board.
Thank you, Keisha, the voice from heaven. Welcome, good afternoon, good morning to some of you. We're delighted to have you attend our Women Get On Board virtual event today. I'm Deborah Rosati, founder and CEO of Women Get On Board. Women Get On Board is a member-based company that connects, promotes, and empowers women to corporate boards. We have over 750 members across Canada. Our membership is diverse, and our goal is quite simply to get one more woman on a board, one board at a time. We're delighted to be hosting a virtual event with our national strategic partner, Gowling WLG, on the topic of shareholder activism, what independent directors need to know. I would like to, so the agenda for today will be, I will introduce our moderator will introduce our panelists, and there'll be a very in-depth discussion. We've got some panelists that have knowledge on both sides of shareholder activism, so we'll be really excited to hear from them. We'll have a Q&A session, and then we'll do a thank you and a wrap up. So, and we promise we will have you out by 1 o'clock. So I would like to introduce our moderator. Our moderator is Greg Peterson. He's a senior partner at Gowling WLG and heads up the firm's corporate finance, M&A, private equity group in the firm's Calgary office. He is also the national co-leader of the firm's governance, activism, and investigations group. So he is well positioned to be the moderator today. He's got an esteemed bio, which we included in the registration page. So without further ado, Greg, over to you. Take it away.
Okay, thank you very much, Deborah, and hello and welcome to our webinar. We appreciate all your attendance at this webinar today, and we hope that you find the information, I'm sure you will, highly beneficial and informative. Our panelist today includes a seasoned practitioner and a highly qualified industry person we have with us today. Start with Elisa Berry. She is the principal and co-founder at IR Labs. Alyssa has over 15 years of investor relations, capital markets, and corporate communications experience. She's raised over $1 billion of capital, led some of Canada's most successful activism campaigns, managed M&A transactions, and enhanced board governance frameworks. She was formerly head of strategic operations and communications at Artis REIT. She was vice president of capital markets and communications at Sandpiper Group and manager of investor relations at Amica Mature Lifestyles Inc. She has lots of experience in this area, and we're very fortunate to have Alyssa with us. Jacob Cocker is a partner in our Gowling's Toronto office, and he's the co-leader of our Gowling's National Governance, Activism, and Investigations Group. Jacob's practice focuses on securities and corporate law with an emphasis in corporate finance, mergers, acquisitions, and special situations. In his practice relating to special situations, Jacob acts for both issuers and activist shareholders, and he advises on complex matters relating to corporate governance, regulatory compliance, related party transactions, as well as proxy regulation and contested shareholders meetings. As Deborah indicated, my name's Greg Peterson, and I have the privilege of being able to moderate this webinar. So I'd like to start with our discussion today with a comment that in today's corporate world, shareholder activism events, they really present unique challenges to directors, especially independent directors, often requiring directors to balance competing stakeholder interest and in the context of hostile situations. So in our webinar today, Jacob and Alyssa are going to provide us some practical tips and strategies on what board members should be thinking about when a shareholder activism event arises, as well as address some of the common concerns that directors may have regarding risks and liabilities and how to manage them. So today we're going to discuss, number one, some common forms of shareholder activism. We're going to talk a little bit about the role of independent directors in a shareholder activism situation. We're going to discuss how to help navigate a company through an activist event, which is quite stressful. And we're going to talk a little bit about how to mitigate risk and liabilities relating to an activist event. So, Alyssa, I'm going to start with you. Can you tell us when is a company likely to be the target of an activist event, or what are some common elements that we should be looking for?
Thanks, Greg. And first of all, thank you, Deborah, for having me. And Greg and Jacob, thank you for letting me be a part of this really exciting conversation that I'm really passionate about. And thanks everyone for joining. Shareholder activism, from my perspective, it should never be a surprise. It's usually due to some underperformance, persistent underperformance. So that's just an overall comment. I believe that shareholder activism also, if you've got contentious transactions or are making certain moves or announcements that may have a bit of a feel that there will be some reaction from the market, you could probably make an assumption that you may be hearing from some vocal shareholders. Just in general, I think that there's usually, in every situation that I've been involved in, there's something governance related. So even though strategy is something that activists tend to focus on and target, I think a lot of activists nowadays are being very opportunistic in identifying governance gaps. And we're seeing a lot more focus on ESG as well. But activism, if a board is surprised that an activist is knocking, there's deeper issues that exist from my perspective. I've been involved in a number of situations over the years, probably about 6 publicly and a few more privately that have settled behind the scenes. And it's never been a surprise in any of those situations. And that's me coming at it from an activist perspective. The company has always seen us coming in some way.
Thank you very much, Alyssa, for that insight. So Jacob, I'll throw it to you now. I'm going to ask you the question. So what is the role of an independent director when faced with a proxy contest or any type of activism situation?
Thanks, Greg. That's basically the title of this webinar. So that's a doozy, but thank you as well, Deborah, and thank you, Greg, for the introduction. Thank you, Deborah, for having us here. I'm very excited to be here. And with you, Alyssa, I know you've got a ton of experience in this area. So the role of the independent director when faced with a proxy contest. So directors, whether independent or not, are charged with the fiduciary duty to act in the best interests of the corporation on which they serve. Independent directors, however, play a special role. They are supposed to be free from direct or indirect material relationships with the company, which makes them uniquely positioned to carry out their fiduciary duty free from certain competing interests that are common in shareholder activist scenarios. For example, in a proxy contest, the goal of the activist is generally to replace management. That could place non-independent or executive directors into a position of conflict to the extent that managing the company is their primary occupation and means of income, and that may cloud their judgment. So this sort of conflict can lead to what's commonly known as entrenchment by management. So the role of independent directors should be to distinguish between management entrenchment that is detrimental to the company versus defensive actions taken in the best interests of the company. This can become difficult because an activist will often just say that management is engaged in entrenchment, whether or not a court would determine whether a particular action taken by a company is entrenchment or not may not be decided unless it goes to litigation, right? So the directors, and particularly the independent directors, are going to need to really assess critically whether actions taken by management or by the company in response to activism is truly entrenchment or not. In many cases, the primary concern of the activist may be with perceived shortcomings or failings of existing management, and that could become very personal to existing management and could result in clouded judgment and less than ideal communications without effective oversight by independent directors. So independent directors have an inherent advantage in being better positioned than the executive directors to evaluate the claims and arguments of an activist from a more detached perspective. And that could enable them to evaluate both the merits and the weaknesses of an activist's arguments more clearly than the executive directors can. So whatever course the company charts in responding to an activist event, whether it decides to sort of seek settlement or to proceed towards conflict, if that's in the best interest of the company, The independent directors should be assessing that course of action through their lens as fiduciaries and actively questioning and assessing whether the course proposed to be taken is truly in the best interest of the company. And in particular, in situations where the thrust of an activist's argument revolves around the executive directors and management of a company, the role of independent directors is critical. Particularly in those situations, other shareholders who are assessing the strength of the activist's arguments and eventually will have to vote on the matter if it goes to a public proxy contest will often look to the independent directors of the company, which could be a special committee formed in response to activism, as a credible source for the company. Whereas management may not, even if management is in the right, they may not be taken as seriously by other shareholders in a situation where management is impugned by an activist. So independent directors are also just simply more difficult for an activist to criticize, provided they're truly independent, because they won't have the sorts of conflicts that I mentioned before of, where, management would have, such as, bonuses on the line, salaries on the line, and that sort of thing. And those are easily attackable by an activist going after a management team, but independent directors don't have those weaknesses. So as a result, in most proxy contests, it is often the most effective and advantageous approach to have the independent directors or the lead independent director be the main point of contact between the company and the activist. And being prepared, as I'm sure we'll discuss throughout this webinar, is key.
Okay, thank you very much, Jacob. And I just want to throw it out to everyone that please feel free to ask questions at any time using the chat function. Jacob and Alyssa will be fully prepared to answer those questions. So if you've got any questions throughout it, just put it into the chat. And as I said, we've got lots of time allotted to answering your questions. So we look forward to all your questions coming through. So Alyssa, I'll throw it back to you now. Can you talk about how a company can prepare for and respond to activist activity?
Thanks, Greg. I think there's two pieces to this. So the prepare for, in my view, is well in advance, and I hope that it results in there never being an activist targeting a company. So it sounds very simple, but it's not. I appreciate that there's a lot that goes into this, but having just a rock solid governance framework is critical. And any gaps that exist, it's really important to prioritize and just address, because an activist is going to look at not only at strategy or whatever else is frustrating to them in the situation, but they're going to look very deep through every document, looking through your proxy circular and identifying those governance gaps. And often it starts with, to be totally honest, it's who's at the boardroom table, typically. So ongoing boardroom refreshment, having honest conversations as a board, sometimes tough conversations around, do we have the right people at the table on a go forward basis is critical in my view. And then just really great shareholder engagement or investor engagement. And I've been in a few situations where it's been known that the CEO hasn't even spoken with the top shareholders for years. And just being proactive in knowing who your investors are, knowing who the investors are that might be a little bit more engaged or a bit more, need a little bit more TLC, and spending time with them. In addition to that, I mean, there's your regular earnings calls and going out and meeting with your investors, but just always coming across as having an open door to your investors is really critical. If an activist comes knocking, that's a different story. And if I were, I'll give you my advice from an issuer perspective through an activist lens, is just assembling that team of advisors really early on, as well as your independent committee or a special committee to handle the situation is really important. And removing all emotion. These are situations that can become very contentious very quickly. Nobody likes to be told that they're doing things poorly, and whenever I've seen something go wrong in our engagement that I've been involved in, it's been due to emotion. And when emotion gets the best of us, we don't always make the best decisions. So making sure that you've got a really solid team of advisors is really, really important right out of the gates if an activist is approaching.
Okay, thank you very much, Alyssa. So Jacob, let's get to some more practicality type things, which I'm sure a lot of the participants would like to really hear about. What tips would you have if an activist asks you to be an independent nominee on a dissident slate? Which I've had that happen to me, and I wished I would have had your answer before I participated on that slate. So go ahead and answer that question.
Yeah, sure, Greg. I mean, I think that would be very flattering for any person to be asked to stand for election on an activist slate as an independent director nominee. Anybody, though, who's asked to do so should carefully evaluate the risks and uncertainties that follow from shareholder activist events. So most activism occurs behind the curtain, free from public scrutiny in what's known as quiet activism. This usually takes the form of letters sent back and forth between the activist and the board regarding the activist concerns and its views on how the board should be comprised or composed, who should resign or who should be added. Many times, if the activist is taken seriously by the target company, this type of quiet activist campaign can result in changes to the board of a target company without going to a full proxy contest. What the public sees could simply be a resignation and appointment of one or more new directors by way of press release when the dust is settled. An activist, and because this type of outcome is quite common in activist scenarios, an activist may suggest to a potential nominee that they believe that a quiet conclusion is the likely outcome for their particular campaign. And use that as sort of like an incentive to suggest this should be pretty straightforward, this should be easy, why don't you join our slate? But potential nominees should be very wary that this is not always the case. So I would recommend that an independent nominee first research the potential activist and ascertain if they have a track record of activism to begin with, and if so, what that track record is before considering joining the slate. As well, an independent nominee should consider the actual thesis of the activist, the main cause for concern that the activist has, and the nominee should evaluate whether they, as a potential future fiduciary of the company, would agree that addressing the concerns of the activist in the way that they're suggesting would be in the best interest of the company. Now, this is an extremely important consideration because a shareholder does not owe a fiduciary duty to the company in which it owns shares, whereas directors do. So if the activist is successful and you are installed as a director of the company, you have to be willing to weigh your duty to the company over your duty to the shareholder who vouched for your election, or your loyalty to the shareholder who vouched for your election, which may be difficult if you haven't fully evaluated the goals and corporate strategy of the activist who supported your election. Now, thirdly, while many activism events occur quietly, public proxy contests are obviously highly public affairs, and sometimes they become public spectacles, and there's risk associated with them. So a carefully tailored nomination agreement between the nominee and the nominating activist would be recommended and would help to protect both the nominee and the activist. So for this kind of an agreement, the nominee would typically agree in writing to stand for election as a director of the target company, but only as a nominee of the activist. And the nominee would typically require that the activist keep him or her fully apprised of developments regarding the potential nomination of the nominee, and agree that no public statements or private correspondence to the company would be made in which the nominee is mentioned without the nominee's prior consent. So this helps ensure that the nominee is actually in the loop on communications and ensures that there's no surprises for the nominee if things go public, or even before they go public when there's discussions with the company. Another thing that you can add in an agreement of that type is, the nominee can require certain conditions in order for him or her to agree to essentially stand as a director. Conditions could include things like ensuring that there's satisfactory D&O indemnity agreements between the nominee and the company if and when they become elected, and matters pertaining to director compensation and that sort of thing. As an independent nominee of an activist, by definition, the nominee is not likely to have any particular skin in the fight, as the nominee should be free from any direct or indirect relationship with the target company that would impair his or her independence. So it may also make sense to request in a nomination agreement an indemnity from the activist in favor of the nominee in respect of claims that may arise against the nominee resulting from the activist's activities, as well as negotiating covenants from the activist that it will not make, untrue statements or omit to say something that it should say, which could attract litigation. These are concerns that I think that, a truly independent nominee should have themselves protected against. So suffice to say, before agreeing to stand for election on an activist slate, the nominee should be very careful that his or her personal interests are protected and that he or she is comfortable with the activist thesis and the proposed direction for the company that the activist is advocating for. And also, obviously, that the nominee actually believes that the activist has the experience and capability of prosecuting a fight against the company, even publicly, because it may come to that.
Okay, thank you very much, Jacob. And Alyssa, Jacob kind of touched on it. If you could follow up, maybe, can you touch on, because I think you got lots of experience in this regard, touch on the process an activist takes to identify nominees for their slates.
Absolutely. And just on a couple of points that Jacob was making, you made some great points. And I think the piece about the track record is critical. We've seen some success this past year with some first-time activists as it relates to the ESG space. So I think that my earlier comment about activists being opportunistic would tie in well with that. But if an activist doesn't have a solid track record or a lot of ownership that's at stake, those are things that, before you sound all of the alarms, those are things that the company, as the issuer, you need to be evaluating. In Canada, just given the number of companies and the smaller market caps, it's a lot easier for an activist to have a significant ownership stake in a company. So, you hear the theory that Canada is more activist friendly for those reasons, and it's a lot easier for activists to build positions going up to that 10%, which potentially may change over the next little while. But those are really great points, because it's important to go through that process. And just building on that, I think it's important to give the practical advice. Really understanding and knowing your shareholders is critical. And if you've got some solid institutional investors, let's just say your institutional investor ownership is 70%, and you know that you're very actively engaged, you're in regular discussions with those firms, those investors, and the activist is coming at you, it's more likely that you're going to, as the issuer, you're going to be in a strong position. However, on the flip side, if you know that you've got that 70% institutional ownership or significant institutional ownership and you haven't been engaging, and there's no significant control blocks that are part of management, so to speak, then you've got to be ready to perhaps go to the mats. In terms of talking through the process, and I know there's a few names that I see that are participating in this webinar who've actually worked with me in activist-like situations. So as what I believe to be a more prepared activist, I've always kept a roster of ready to go board members. So it's never a scramble. And when the activist is approaching the company, typically they've been doing their homework, and there's a lot of lead up. It could be for months, or it could be a whole year's time where they've been waiting for a whole proxy season or a whole AGM season to get ready for whatever they're working on. So the activist is way ahead of the issuer typically. So I think that's important to remember. An activist is going to be successful if they choose the right people to be on the board. And so in terms of a process that we've always run from an activist perspective is socializing an opportunity with the potential nominee, having them sign confidentiality, and going through a bit of a conflict check. So you want to make sure that the nominee that you're approaching doesn't have a bunch of friends in the boardroom or conflicts with management or anything from that perspective, and getting their perspective on the situation. So I've always given my nominees our sort of, we call it the fight deck in the activist world, and walking them through the thesis. And at the end of that exercise, they say, you know what, I can get behind this. I see what you're saying, and I'm in. Or it's I can't support you on this, but good luck. And those are sort of the two situations that or responses that I've always received. And then keeping those nominees involved throughout the process. An activist is often going to have more nominees in their back pocket than needed as well, in case that someone falls off or chooses not to be a part of the situation, depending where it goes. And the right thing to do from an activist perspective, and I've seen this in the settlements that we've been involved in, is to give the company a couple of names. So I do believe that that's a best practice, rather than saying, here's our name, sign on the dotted line, and let's get this done. It's, we as an activist, if we're advocating for good governance, let's go through a process of presenting 2 or 3 nominees to a governance committee that a chair of the board and perhaps the CEO would be involved in as well, and having them vet, because at the end of the day, you want to make sure that the individuals you're putting forward are going to actually add value. And make sure that there's a right personality, cultural fit at the end of the day. I've had activist nominees that I've had prospective nominees come to me saying, this is the next challenge for me from a board perspective. I've served on a lot of boards. Now I want to be a part of an activist slate. And they see that as sort of an exciting kind of next level challenge, which is really neat. So I've always had a very positive experience in engaging with prospective nominees.
Okay, so Alyssa, can you just briefly, is there a correlation between investor engagement and shareholder activism?
Yeah, I've touched on that a little bit. I 100% believe that great, solid shareholder engagement will minimize the impact of shareholder activism. And then in the pursuit of activism, or if activism, if a company is targeted, having that engagement throughout the process and very, very early on with the investors is critical. Again, in all the situations I've ever seen or been involved in, it's because of many things, but the poor investor engagement has always played a role for sure.
Okay, thanks, Alyssa. Jacob, I'll throw one at you now. What steps can independent directors do to protect themselves when considering joining a board related to an activist event?
Well, as a practical matter, one major thing that all directors should be doing is ensuring that there's a protective indemnity agreement in place between themselves and the company. And I think this should be entered into almost as a condition to agreeing to serve on a company's board of directors. So many times, as you know, Greg, the bylaws or articles of a company will contain provisions that require the company to indemnify directors and officers for claims brought against them in connection with their activities in service to the company. But it's important to note that bylaws can be changed, including after a director departs from a company, whether as a result of their own voluntary resignation or because they may have lost an election in a proxy fight. And proxy fights can get bitter and very personal. So an indemnity agreement between the individual director and the company can't be changed without the consent of that director. And the other thing that should be considered as a matter of housekeeping is the adequacy of director and officer liability insurance. So often in a proxy contest, there are insults hurled and accusations made about the intentions and motivations of management on the one hand or the dissident on the other hand. It's not unusual for the most bitterly fought proxy contest to involve some level of litigation in one form or another. Maybe not directed at directors and officers, but litigation can be used as a strategy. And all of this conflict increases the risk profile for existing directors who may feel like they need to make difficult decisions in the best interests of the company in order to fully discharge their fiduciary duties. But, those are difficult decisions because they're fraught with, they may be concerned about personal risk. So having fulsome and adequate D&O insurance provides a level of peace of mind, and making sure that the indemnity agreement that I spoke about has covenants about maintaining such insurance will help directors feel a bit more confident during a public proxy contest which are very stressful, and where they may need to make the most difficult decisions that they need to make as directors. And so another less legalistic step that independent directors can do to protect themselves, and this touches, I think, on a bit about what Alyssa was talking about, is that ensure there are open lines of communication between themselves and the other independent directors. Ideally formalized as part of the schedule of directors meetings, where independent directors may conduct in-camera sessions among themselves without management present. A strong connection between all the independent directors will help ensure that their voice as the independent board remains strong in the boardroom, which may not be needed all the time, but will be needed in the, if a shareholder activism event arises, in addition to other situations requiring strong independence. Another thing that independent directors should involve themselves in are, of course, investor relations matters. Oftentimes, a common complaint of an activist, whether on its own or as part of a series of additional concerns, is as Alyssa has mentioned too, a lack of engagement or inadequate communications with shareholders. So it's important that the independent directors understand how shareholders are being contacted by the company and what is being said to them, and by what means. Having open lines of communication between independent directors and, say, the IR department within the company or with an IR provider could bring matters to the attention of independent directors that impact shareholder engagement before it becomes a more serious problem. Finally, for a company that may have an inkling that shareholder activism may be on the horizon, which could be indicated by a variety of things, such as the filing of a new early warning report from a person nobody knew was a shareholder before, or if the company has recently changed its corporate strategy, or if there's been an M&A transaction, a sizable one, and integration could be a concern after a year or so, or there's disappointing corporate results released or other adverse events. All of these things can be harbingers of activism. It may be prudent for the board to actually proactively prepare for activism. This is something that was touched on earlier. And so independent directors can do this by asking experienced counsel to assess the vulnerability of the company to activism, a sort of review of the company's articles, its policies, its governance history, its capital structure, as well as setting up a framework where all relevant stakeholders, such as management and the board and the investor relations team and communications and other participants, actively prepare a sort of situation planning for a number of common activist scenarios, which would enable coordinated and fast response to common forms of activist events, whether it comes in the form of a letter to the board or a public white paper by a dissident, or a requisition for a meeting of shareholders or other types of events. A board can prepare for that. And independent directors have a strong role to play in that sort of thing.
Okay, thank you very much, Jacob. So following up on that, Alyssa, do you have any tips that you could provide for someone considering joining an activist slate?
Yeah, I think you need to be a bit of an activist by nature. You need a strong voice if you're going to take on that role and that responsibility. Whenever I've interviewed prospective nominees, I've always asked, do you want to be a part of a settlement, or if this goes to the mats, are you willing to be a part of the public fight? And so knowing, as a director, knowing how involved you want to be in the process is really important. And being ready to also know that your former TSR, so your track record on other boards, and any skeletons that you have in the closet, talking through that with the activist and being upfront about that is really critical, because those are things that the issuer is going to potentially target as they're trying to pick apart your slate. So just being prepared, you have to have a thick skin ultimately. And if you're one of the things that if I were looking to become an independent nominee representing an activist, am I the only one that's going to be in that boardroom, or are we looking at replacing a number of individuals? Can I collaborate with that other person that is also independent? Am I aligned? In my experience, one is never enough, and I've been involved in situations that we've settled with one and then had to go back years later and resolve other issues that have just remained. So going through that assessment or understanding your sort of role within the process, I think is really critical. And be prepared to roll up your sleeves. It's a lot of work advocating for change, especially once all eyes are on the company post settlement or post proxy contest.
Yeah, good point. Because I know that the ones I've been involved with, they're very stressful, and you really would like to get the proper advisors, and you need help. It's a stressful time. So, Alyssa, following up on that, what would be your advice to, say, companies to ensure an activist never comes knocking?
Yeah, I think we've, to sum up a lot of what we've said throughout this, is just having great engagement, listening to your shareholders. If shareholders are presenting ideas, taking those back and reflecting on them, I think is really important. A clearly articulated strategy is really key. So when I've looked from an activist perspective, I'm reviewing the annual letter to shareholders, I'm going through the MD&A or your AIF, and it's been the same strategy, copy paste for the last 10 years with nothing new and visionary. And it's very clear that shareholders, or you look at your share price or unit price and see, obviously there's something wrong here. So making sure that you're constantly as a board refreshing your strategy or looking at strategy and making sure that you're properly articulating that to your shareholders, I think is really key. And having just a very strong governance framework. Again, I mentioned at the beginning, where there are gaps, fix them. And really, I think there's a lot of opportunity now, not only for governance committees, but leveraging, if a governance committee identifies issues, leverage the investor relations department, leverage the legal department, leverage others within the company to help address that as quickly as possible. I think that's really important. And on that note, activists can also identify band-aids as well. So doing it properly is also really important. And if something's wrong, fix it.
Yeah. Okay. Well, Jacob, I'll throw the last question at you, and I'll flip the coin on this. So what advice would you provide to an entity that wanted to pursue a shareholder activist strategy against a company?
Okay, so the answer to that question is very varied and highly contextual. So I'll assume we're speaking about an activist that has no prior history of activism, because those companies or entities that have instigated activism events, they're already familiar somewhat with the process and they know what to expect. So, and I'll also assume that by activism here, we're really just talking about, replacing management through a traditional proxy fight, whether publicly or privately, but there's obviously other kinds of activism. So like the main advantage that a company has, I know we're going to talk about the activists, but the main advantage of the company is the incumbency advantage. So the existing management's already there. They're already in control of the corporate message, the corporate resources they have control over, and presumably they're already familiar with their shareholder base, or hopefully they are. This advantage applies to management throughout the activism event, right? They're always going to have that incumbency advantage until they're defeated. And so this is one of the reasons, I think, why typically management wins most proxy contests. But the activist has a very, very good advantage too. It's a knowledge advantage. So the activist actually knows that it's going to pursue an activist agenda, and it knows this well before the company does. And that is a huge advantage. So this advantage, though, is lost as soon as the activist makes itself known to the company through a demand or whatnot. As a well-organized company will typically gear up for a potential fight as soon as it learns that there might be one on the horizon. Even before a demand is made, if the company learns that this person is after change, they may start preparing. So that information or that knowledge advantage that the activist has is very important, but it's only temporary. So because of the incumbency advantage that the company has throughout the activism event, an activist should use its knowledge advantage to the best possible effect and as Alyssa had mentioned, and in her experience, I think it's correct too, by meticulously organizing resources and strategy and refining your messaging and your thesis prior to firing the first volley at management, whether publicly or privately, is very important for the activist in order to have the greatest effect. In a traditional proxy contest with a shareholder activist, the threshold question really is how much skin in the game the activist has. So, if, for example, an activist shareholder's concern is that existing management of a target is subpar, then in terms of their management abilities, their direction for the company, then the question is, how significant of a shareholder is this activist? If they're not a significant shareholder, they may not be taken seriously by either or both of management and the other company shareholders. So an activist in that position, in addition to preparing, may want to evaluate whether their share position is significant enough or whether they want to maybe acquire a larger and stronger share position in advance of a campaign. A sizable investment in the company will lend credibility to the activist when it comes time to convince other shareholders that it is truly concerned about the company's direction under current management and that its alternative approach should be taken seriously. And of course, there's lots of legal rules around acquiring shares and certain reporting thresholds that are triggered at certain ownership thresholds. So it's important for the potential activist to be mindful of these and to be communicating with counsel at an early stage. On the other hand, another form of potential activist is a stakeholder that's not really a shareholder, that has an interest in pursuing an activist agenda against a company in line with whatever its stakeholder positions are. And in that case, the suggested approach might be different. So this could include, for example, a special interest group that may not be significantly invested in the company, but has an interest in activities the company's engaged in. In this situation, another strategy might be more effective rather than like acquiring shares and trying to replace the board, such as, for example, submitting a shareholder proposal, which is that's a shareholder rights mechanism that forces the target to publicly, if you do it properly, it forces the target to publicly address the issue of concern in their proxy materials. These types of strategies can be very effective, because often, if the proposal is submitted early enough, it can result in engagement with the company and a level of access for the activist with management that otherwise wouldn't have been possible for somebody who isn't a significant shareholder. And in those cases, I've seen, companies may want to try to strike a deal with the proposer or the activist proposer in exchange for the withdrawal of the proposal. So this sort of strategy doesn't even require significant share investment. So in the context of a traditional proxy contest to replace the whole board, there are many other considerations that an activist should be mindful of. I mean, first and foremost, any communications in the lead up to an activist event should be carefully controlled and scripted. There are strict proxy solicitation requirements that, if they're not adhered to, could basically undo the victory that an activist may achieve before a fight even begins, by resulting in proxies being thrown out. So, and of course, the activist should be, very mindful of the soundness of its thesis, its concern that's driving the activist to seek change in management, as well as the quality of its nominees. If the concern is mainly financial, then it could be worth retaining a financial advisor, which, if the financial advisor were to concur with the activist thesis, could lend additional weight and credibility to the activist argument when it's put to shareholders or the company. And of course, messaging is centrally important. It's often money well spent to hire an experienced communications firm and a proxy solicitor to help shape the message and engage in effective outreach campaigns to shareholders.
Okay, thanks, Jacob. That's good for companies to also be aware of, because I'll use a football terminology. A good defense is knowing the plays of the offense. So if you're on Alyssa's side and you're acting for companies, it's always good to know what the activists want to do. So we're going to now flip to some of the questions. And we got about 10 minutes to answer these. So I'll throw these out to Alyssa and to Jacob. Jacob, maybe I'll throw this one to you. Can you provide your insights on the CN saga unfolding?
Yeah, I mean, so I don't know if I want to comment specifically on that.
Yeah, be careful what you say now.
Yeah. But it's a requisitioned meeting, and typically in a requisitioned meeting, they are very carefully thought out. There's a lot of strategy involved, and so the requisitioning shareholder will be very careful about making sure that they are bulletproof on their share ownership. They are in control, right? They're not, they decide when they want to requisition a meeting. So the timing of a requisition in relation to surrounding corporate events is, something that might be interesting to look at in general for any requisition meeting. They typically make the requisition, and that can often just open up the dialogue with the company. Oftentimes an activist who's interested in exercising a requisition right will, submit a draft requisition to the board, but that often just gives the company, that results in the activist losing its informational advantage, which I just described, right? So I find the most effective strategy, because a requisitioning shareholder needs to only own 5%. You don't need to be that significant of a shareholder to requisition a meeting, but if you do your requisition properly, the board has to call your meeting. So the most effective strategy in my experience has been to actually just go ahead and requisition that meeting. The board then has a period of time to evaluate the requisition and decide whether it's validly made or not. And if it's validly made, then they have to call the meeting, or the shareholder who requisitioned the meeting has the ability to do that. And so during that time period, you often have some engagement, which can be public or private, between the requisitioning shareholder and the company, which can result in a settlement. And sometimes for requisition meetings, you end up just having an agreed slate that may be a mix of management and dissident nominees that ends up being put to shareholders to vote on. So it's every move in a requisitioned sort of event, a requisition meeting event is very strategically made, and every move is very carefully thought out. So I think that's I would just add that as my general response to a requisition meeting.
Okay, thanks, Jacob. I think this next question is perfectly fit for Alyssa, who's got more experience than us lawyers here in media. Alyssa, the question is, considering the situation where an activist has engaged, what do you recommend to keep the situation out of the media? We are recently seeing many unfold in the media. I can only imagine that this would not be optimal for either party. What do you recommend to help keep the publicity at a minimum?
So I think just taking a step back, why activism in the first place? And the activist is targeting because they're trying to make money, like, just to put it quite simply. Like, they've invested significant capital. If they are a savvy activist, they have a lot of capital on the line. So an activist does not want to go through the same emotion that the issuer doesn't want to go through, the slinging mud, and like, really truly the activist doesn't want that either. So I think going into the situation, trying to aim for a settlement or a quiet conversation is the best way to keep it out of the media. An activist, if they're met with any, if they're rebuffed by the company in trying to engage, they're going to use every tool at their disposal to try and get their message across. And by the time an activist has hired lawyers, proxy advisors, potentially a communications firm, a media firm, it's racking up very quickly for that activist as well in terms of their expenses. And if they don't get what they want, they'll use every tool to try and ensure that that they do. So I think just knowing the motivations of an activist, they're there because they're trying to create value, obviously for themselves and for all other shareholders, and just really trying to avoid any. The moment that first press release, that opening salvo, as we call it, is launched, I mean, you've lost all opportunity to try and keep it out of the public at that point. And it obviously depends on the size of the company and the contentious situation. We've obviously seen some very high-profile situations recently in the media, just because they're household names. So certainly, it's going to be dependent on the market cap and the significance of the company. But yeah, just trying to ensure that first press release is never launched is the goal.
Okay, thanks, Alyssa. So Jacob, do you have anything to add on that?
Yeah, I think I agree with that 100%. And sometimes you can you know, get further engagement with the company by submitting a draft of a press release, perhaps. Although that could also tip your hand and allow the company to start thinking about counter arguments. I think as Alyssa said, once the press release is out, the cat's out of the bag, right? And then it's up to news outlets as to whether they want to report on the activism or not, which they may not do, right? There's lots of small companies that are hit with activism events and they're not widely reported in the news, but there are press releases about it out there that you can find. Sometimes an initial press release by an activist is effective in permitting a dialogue that can occur and result in a settlement quietly. And so there can sometimes be strategy around, an initial public announcement. Of course, it would have to be carefully done, not to be, too inflammatory or rile up, make the situation worse than it has to be in order to have a dialogue. That can sometimes be effective in allowing a company, if you're from an activist perspective, allowing the company to realize they need to take this seriously. But yeah, I think quiet activism is the majority of activism, and it all occurs behind the scenes without publicity.
Okay, thanks, Jacob. So there's two more questions in the chat, and I'll throw one out to Jacob and one out to Alyssa. So Alyssa, I'll first throw this one out to you, and we have about 4 to 5 minutes left. Very important question by this person. How do you know which are the right advisors? How do you identify them?
Yeah, so there's only so many advisors in this country as it relates to proxy advisors and comms firms. So I think just having typically around your boardroom table, you're going to have people with a Rolodex and relationships, and typically someone's going to know that proxy advisor or this legal firm. So I think really spending the time as a board to kind of share notes and share contacts and experiences. I think it's generally known now that in most boardrooms, there's likely going to be one person who's been through an activist-like situation at some point, or they're going to know someone who has. So knowing who to talk to and have that feedback. And I think just as a board member, just knowing who the players are and having the odd coffee or a chat with your proxy advisors in the country, even if you don't expect or ever believe that you're going to be in a situation like that, just knowing that you do have you've had that opportunity to start vetting these individuals if you ever do need them. I would just leverage your network to talk to others who can provide experience or feedback and seek proposals from everybody. Certainly it's not always settling for the name brand firm. It's making sure that you're getting good value for whatever it is that you're seeking advice on, whether it's proxy or legal or on the comm side.
Okay, thanks, Alyssa. And we got 2 minutes, Jacob. Last question for you. Do you believe that the board chair or lead independent director has a role with the CEO or in addition to in meeting with investors/shareholders?
So in an activism context, as I said before, I think that in fact, for a serious activist where the board is, where the activist has indicated and has provided evidence that it's willing to go all the way in a real fight, the board chair or the lead independent director has a very important role to play. They may actually be the one who's best suited to be engaging with the activist in addition to the IR team. The CEO certainly has a role to play too. It depends on the context though. So for example, if the activist is dissatisfied with the CEO or there's some personal issue there with the CEO, then the CEO's role there may not be as helpful, but it may be. I mean, it really depends on the situation. But certainly the board chair, the lead independent director, I think has a very important role to play in an activist scenario. And that only becomes more important the more serious the activism scenario is or becomes, for sure.
Okay, well, Jacob and Alyssa, thank you very much for sharing your experience and in-depth knowledge with us today on this very important topic. And we'd like to thank all of you for participation in this webinar. And Deborah, I will turn it back to you.
Okay. Thank you. Delighted to thank you, Greg, for keeping us on time. Thank you, Alyssa and Jacob, for your really in-depth conversations to sort of look at it from both sides. I think I certainly hope I'm always on the quiet side, not on the public side, if I ever encounter a shareholder activist event. We really appreciate your time and your insights that you shared with us today. So Women Get on Board likes to make a donation to our charity partner, which is Dress for Success, the Toronto chapter. So on your behalf and your time and your insights, we'll be making a donation. So thank you. I'd like to thank Gowling WLG for being our sponsor today as our national strategic partner. Greg, I think this is probably your third or fourth event we've done with us. We'll just take you on the road. Not quite like broadcasting the Stampede game, but broadcasting Women Get on Board events, nothing wrong with that.
That would be sometimes better than practicing law. So I'll consider that.
Thank you. So just to keep everyone informed, our next Women Get on Board virtual session is November 30th. And the topic is purpose-led companies, the role of the board. Hope you will be able to join us. Post this event, you'll be receiving a thank you, a follow-up survey. Love to get your feedback on our survey. And in the next few days, you'll get a recording from this session. And I think that's all we have for today. And we want to make sure you are out the door by 1. So thank you, stay well, and be well.